Hi comrades, yours Kayveeyes. Today let us discuss about the present position about the grant of notional increment to the June 30th and December 31st retirees. What is the case first of all? It is very clear that the decision of the Supreme Court has not yet been implemented by the Department of Personnel and Ministry of Finance. Even though several judgments followed by several SLPs dismissed by the Supreme Court, it was very clear and evident the judgment should be implemented to all the similarly situated persons of the case. Initially, the implementation of the Ayamperumal case decision, which was decided on 15/9/2017, that is 6 years before, in WP number 15732 of 2017, to all the similarly situated employees has not been ordered due to the interim order in the case of Siddharaj versus Railways by the Supreme Court. The Supreme Court in the SLP 4722 of 2021 passed an interim order on 5/4/2021 for the stay of operation of Karnataka High Court decision in the case of M. Siddharaj versus Railway, granting one national increment to him. Based on the stay only, the decision was not implemented to all the similarly situated persons because of the only one order which was passed by the Supreme Court as an interim order on 5/4/2021. This has not been implemented, even though several cases have been dismissed by the Supreme Court in the SLP as well as the curative petitions. The issue was discussed in the Standing Committee meeting held in December 2022, wherein it was replied that it will be decided based on the decision of the SLP in the case of Siddharaj versus Railway in the Supreme Court. The SLP of Siddharaj 4722 of 2021 was dismissed in the Supreme Court on 19/5/2023. As such, the assurance given in the September 2022 has to be implemented by the government as well as the DOPT and nodal ministries, since the case of Siddharaj was dismissed on 19/5/2023 and the SLP has and also the curative petition has no hold after this. The government as assured must implement the same to all the similarly situated persons. Similarly, and also subsequently, umpteen number of judgments were delivered in various courts, and even all the curative petitions were dismissed with the directions to implement the same not only to the concerned applicants but also to the similarly situated officials. The judgments were very specific to implement the same to all the similarly situated persons. On 26/6/2023, the DOPT has informed that the issue is under examination in consultation with the Department of Expenditure. On completion of the process, action will be taken. We were very anxious because the DOPT has assured that it is under the examination and we were awaiting orders since 26/6/2023 over 8 months. In the meantime, the Comptroller and Auditor General of India issued orders on 13/6/2023 allowing the benefits only to the pensioners who were party to the cases. It was not implemented to others, only to the persons who approached the court. Subsequently, on 18/1/2024, the same Comptroller and Auditor General of India extended the benefits to all those retiring 30th June or 31st December with effect from 30/6/2023 only. It has been implemented only with effect from 30/6/2023 as per the orders of the Comptroller and Auditor General of India. The Railway Board, in the meanwhile, on 10/7/2023, directed its units not to challenge similar cases further, since it will be a futile exercise after 19/5/2023 judgment. only time can be sought for compliance of orders. The ministry is persistently following with the DOPT. This was the content of 10/7/2023 instructions. The Ministry of Defense also forwarded the representation for consideration by the DOPT on 21/6/2023. The DOPT, by its letter dated 6/7/2023, informed about the extension of the judgment to the similarly placed non-petitioner employees is under examination and also in consultation with the Department of Expenditure. The DOPT, by its letter dated 6/11/2023, after 4 months, had directed to take administrative decisions on complying with the court orders on the subject matter. There was no mention about the implementation of the same to the similarly situated persons. Based on the above, the Ministry of Mines, by its letter dated 29/12/2023, has directed to consider the post-receipt of applications as per the Supreme Court order dated 11/4/2023. Accordingly, in the Ministry of Mines, this has been implemented to all the similarly situated persons who are making representation for the implementation of the same. The Department of Post has initially implemented the judgment in 5 or 6 cases in Tamil Nadu Circuit. Thereafter, the Department of Post, by its letter dated 12/10/2023, has directed the GPMG Tamil Nadu Circle to challenge the fresh petitions coming up for new cases after that. In the Standing Committee meeting of the JCM held on 15/12/2023, the staff side protested against the undue delay in causing orders to implement the same to all the similarly situated persons. The additional secretary had informed that the issue is in advanced stage of consideration and the DOPT would take a decision in this regard very soon. Whereas the DOPT, by its note dated 15/1/2024, has suggested the Ministry of Defense that the consultation to resolve the issues is underway and likely to take some time. The department may take cognizance of the position and prepare suitable counter for the remaining cases. Thereafter, the Department of Post, by its letter dated 31/1/2024, has approved the cases of 16 individuals who fought the cases in the court and directed to implement the same. The Ministry of Information and Technology, by its letter dated 12/2/2024, extended this benefit to 2 officials and also extended the benefits to all the similarly situated employees in the department based on the guidelines of the DOPT. Central Public Works Department, the CPWD department, by its letter dated 22/2024, has extended the benefits to the officials who have approached the court. There is no mention about the implementation of the same to the similarly situated officials. The Railway Board, by its letter dated February 2024, has directed to extend the benefit of notional increment only to the contempt cases. If the concerned applicants filed a contempt, then it can be implemented. For rest of the others, keep it silent only. After getting the guidelines from the DOPT, the remaining will be dealt. These are all the developments. For more than 8 months, the DOPT and Ministry of Finance are taking time to have consultation to implement it. But a great shock has been felt to read the minutes of the SCOBA meeting held on 22nd February 2024, just a week before. In the meeting, it was replied, after mentioning the court orders, that there was no reference to the relevant fundamental rules governing the annual increment. Actually, the Supreme Court has given the orders. The fundamental rules, there is no mention about the grant of increment after the completion of 12 months or 6 months. But without any amending the fundamental rules, how can it be implemented? This is a present position taken by the government. by the DOPT. They are saying this was examined and the learned Attorney General was consulted. In pursuance thereof, efforts are being made to seek clarification from the Honorable Supreme Court on the relevant issues, including rule provisions which need elucidation. Action to implement the Supreme Court orders can be taken only on completion of the said exercise. It is very clear now. As per the SCOVA minutes, all of you know about the SCOVA. It is a pensioners forum. In the meeting, the DOPT representative has given it in writing. The minutes is very much available. Everybody can see it. In which they are saying, unless amending the fundamental rules, there is no chance of implementing the Supreme Court orders, and we are going to approach the Supreme Court again, whether the fundamental rules will attract, whether it can be implemented, what to do like this. They want to have a consultation with the Supreme Court and they want to move with the Supreme Court once again. It is most unfortunate. I can say the word, it is most unfortunate. A government, a model employer should be a model employer, and he should not dilly-dallying the issues related to the central government employees as well as the pensioners. One of the pensioner association I have seen that they are saying we have no alternate and directed the pensioner to file the cases separately. It is totally miserable. We cannot say like this. It is very shameful also on our part. Many state governments like Tamil Nadu, Andhra, Maharashtra, Chhattisgarh, etc., they have already issued orders granting notional increment to its employees. As such, asking individual to apply a fresh case is not a good move or good decision. The intention of the government is very well known. It wants to drag on the issue by seeking clarification from the Supreme Court about the changes required in the fundamental rules. It can be done by the government itself. They can amend the fundamental rules if need be. If they want to implement the orders, they can amend the fundamental rules also. We should exercise a serious pressure upon the government. It is not the case of pensioner alone, and it is related to the serving employees also. More than 10% of the pensioners as well as the serving employees will be benefited if the Supreme Court order is implemented. The JCM's staff side should not be a silent spectator. It should move very fast. We are expecting the JCM staff side to act at least very swiftly at this juncture, and instead of approaching the Supreme Court, it can be settled by the government by amending the fundamental rules. This can be very well taken up by the JCM staff side. According to me, they can delay it, but they cannot deny it. But the government want to deny, and they want to see some of the pensioners who could not have the benefit at the time of their lifetime. That is the only thing the government can do it. But it cannot permanently stop these thereafter also. Let us wait for some more time and don't suggest for filing individual cases by the pensioners. Instead, a serious postcard campaign, a serious program of action that should be initiated by all the pensioner association as well as the serving employees organization, unions and association, to insist the government to implement the Supreme Court decision immediately without again referring to Supreme Court. This is the need of the hour. Comrades, don't think I am shattering your hopes and wishes. You are all expecting when orders will come. I was also one of the person very ambitiously awaiting for the orders. But I want to say the real position. After seeing the SCOVA minutes, I came to this conclusion, and I hope that the prudence of all the central government employees organization and pensioner association should be properly moved together in order to mitigate these serious demand of the pensioners as well as the central government employees. With this, I am concluding. Thank you very much, comrade. Meet again.